with that? Knock, knock, knock. Call the,
Oh, we could have brought that, we could have brought the gavel, yeah.
the August 17th, 22 Board of Zoning Appeals meeting to order. For those of you who have never been to one, I'll kind of give you how it's going to go. The staff will present the cases to us and read their staff report and everything to us. At that time, the board may question the staff. Once that is done, then we'll open it up to public, and we'll start out with people for the request, and once they're done, we'll ask people against the request to come up and speak. Once all of that is done, the board, we close the public hearing and aspect of it, and then we start talking amongst ourselves on how we want it. If we need information, we'll call up who we think from the audience that would best be able to answer it from us. But at that time, please, we don't want any, or nor will we take any statements from the audience during ours. If we have a question or concern, we'll call upon the people to come up and do it. We want to give everybody an opportunity to come up and speak who wants to speak, and it's very important. Speak loudly because of the fact that we're not in our normal room, and the audio may or may not be able to pick up with good clarity unless it's you speak with someone forcefully. With that, we have roll call.
Roll call. Mr. Martinsek?
Here.
Mr. Thomas?
Here.
Ms. Goldwall?
Here.
Mr. Henry?
Here.
Sure. Just point of order, want to approve the agenda as one of the first things we do after a roll.
Okay. Do I hear a motion to approve the agenda?
Go ahead.
I make a motion to approve the agenda for the August 17, 2022 meeting.
A second.
All in favor?
Aye.
Aye. Okay.
Excellent. So what I'm going to do is I'm going to start by reading the public notice that was sent out. The Board of Zoning Appeals case number 862, requests made by property owners Sean and Jacqueline Smith for the property located at 1778 Ash Meadow Court, Greene County parcel ID B03-0003-8000-9900. The nature of the request is to seek a variance from the requirement that accessory structures must be located not less than 10 feet from side or rear lot lines, and that's pursuant to Article 18.053 of the Township Zoning Resolution. The parcel is currently zoned PUD R1AA. The applicant desires to allow an existing pool house structure, and I was corrected later. It's not like a it doesn't store pool chemicals or anything like that. It's more of like a shed. To remain located closer to their property line, less than the 10 feet allowed. And then I did prepare a staff report that I'll read to you quickly. So for some introduction, again, the applicants in the case, Sean and Jacqueline Smith, are the owners of 1778 Ash Meadow. They're requesting the variance from Article 18.053, which states, when located at least 60 feet from the front property line and completely to the rear of the main dwelling, an accessory building or structure may be erected not less than 10 feet from the side or rear lot lines. The applicant actually purchased this home after the violating shed was built by a previous owner. They were not aware that there was an existing zoning violation on the property at the time. It's pretty common. However, the violation was brought to staff's attention via communication from a neighboring resident after that resident had a survey of their property lines conducted. So besides the shed being located too close to the property line, a portion of the fence at 1778 Ash Meadow and a portion of some Concrete and some landscaping elements are located actually, as far as we can tell from the survey results, on the parcel belonging to Randall and Polly Staggs at 1800 Ash Meadow Court. Now, that in itself is not what's at issue here. The zoning do not get involved in property line
We
disputes.
cannot do that.
But it is it's a fact of the case at this point, and it kind of works its way into my recommendations that I'll talk about a little bit. So, in conversation with the applicant, staff does believe that the applicant is aware of the need to remove the fence and concrete and things that are on their neighbor's property. And we believe that from conversations that they're okay with making those adjustments. I don't think that's a point of contention any longer. However, the zoning issue here is that the shed is located just a little bit closer than the 10 feet allowable. And so they need to at least get a variance if that's to be left the way it is. So a little bit of context. So in responding to kind of the criteria that needs to be met to grant a variance, the applicants made a number of references to the structure existing since 2003 with no incident or issue. And while that is the case, you know, a violation that's existed for a long time is still a violation. So while we're quite certain there was no ill intent, especially from the applicant who had nothing to do with the building and structure, just because it's remained for a long time is not a good reason to allow it to remain without other considerations being made. So I did want to go over that. And then, so while previous neighbors may have had no issue with the current shed location, the new neighbors who have made residence at 1800 Ash Meadow, they've communicated with staff that they're not happy with the location of the shed. This is in direct conflict with criteria number 4, which talks about, it says that the granting of variance would not be injurious to surrounding properties and property owners. So that should be considered at least when determining whether or not to grant a variance. And I'm pretty sure that the Staggs or one of the Staggs will be here and they'll speak their piece, but we know from conversations with staff that that's the feeling on that. On the other hand, moving a shed which is sunk into a concrete pad is a significant expense. Considering that the shed is encroaching by about 2.5 feet, the expense of moving the shed may outweigh any benefit gained by adhering strictly to the zoning resolution. The BZA should weigh the potential for neighboring properties to be injured against the potential injury or cost to the applicants in the expense of moving the existing structure. Additionally, it should be noted when deciding to grant a variance that the applicants were, again, not the original installers of the shed, fence, or concrete pad, and could not have prevented this zoning violation in any way. So staff does have a recommendation. We do recommend granting the proposed variance, but we have a couple of conditions that I think we should be applying to the variance in order to attempt to resolve some of the surrounding issues as well. So the suggested conditions to allow the variance are here. And first, the applicant must remove the section of fence, the concrete, and the landscaping feature which are located past their own property line and on the property of 1800 Ash Meadow Court. Second, the removal of the features described above must be completed within 60 days from the granting of the variance. So that kind of puts a bit of a time limit on it as well. The applicant must file a revised permit application, which has no associated fee, to staff to ensure that the correct fence location is recorded in township records. So basically, hey, once you've fixed it and situated it, give us a new plot plan so we can have it in our records that says this is the location of the various shed and fence and things like that. And then 4, if the above conditions are not met, then any variance granted becomes null and void, and at which point the shed must be relocated and must comply with the township zoning resolution. So those are the 4 conditions that we would recommend if a variance was granted. And just another quick point, if the residents at 1778 Ash Meadow Court truly feel that the existing said location is injurious to them and their property, then in staff's opinion, that would mean at least one criteria for granting the variance is not met. And that does need to be considered when making the final determination. So I know it's a tough one. Oftentimes I come in here and I'll say, look, our staff report, or our public hearing notice serves as a staff report, which means we have no additional comments or issues. This one is something that needs to be sussed out a little bit. So I'm glad to answer any questions about my staff report at this time. And I do have some photos and stuff I'd like to show you as well.
I'd like to do we have a history of when the fence and the shed was put in?
I would have to refer to the original permit, but it was 2003 or 4. It was quite a while ago.
Okay, I guess my question was there a survey done at that point? I mean, how did they, how did they not know they were encroaching into their neighbor's yard?
That I don't know.
A fence permit only requires a hand-drawn
Right. and
diagram. and
especially back in
basically draw a dotted
2003.
line, and the fence variance is, or the fence permit is granted.
Yeah, that's essentially it, right? You would say, here's my plot plan. I've drawn it to show that it's on the property line.
But going by what you're giving me and looking at this, can I assume the fence is roughly 2 feet in the neighbor's yard?
Yeah, I'd say that's about right.
Yeah, that's a huge offset in this.
Well, you gotta consider in here, I think this might help kind of illustrate how something like that could be missed. I mean, the size of the lots are quite large. Typically, your surveyor pin, which is the only tool we might have to try and locate a property line, is gonna be here. And the fence is all the way back here. Now, if you're using non-electronic methods, you could very easily veer off by a couple of feet by the time you've walked back, 60 or 70 feet. That being said, it could also be that the neighbors at the time had a strong relationship, and so maybe it was noticed, and the one neighbor said, you know what, but we don't have the ability to ask.
We don't have the history back there. And what's been the history in the house resale? Are they the second owner since the fence was put in, or the first owner since the fence was put in, do you know?
I believe they are the applicants are here, is that correct?
Yes.
Okay. Are you able to answer that question?
Yeah, we're the second owners.
Thank
The
you.
original owners put the fence in. And that fence, the corner of it is off 2 foot, not the whole line.
It's only, what have you come up?
Yeah, he's just answering the question. he's
Right, I
asked.
understand, but I want to make sure we.
I understand.
Get it on our record.
So yes, I believe that they are the second owners, but after the fence was built, they're the next owner.
Okay.
I am curious
Thank
in 2003 exactly when that shed went up.
I would need to refer to the permit, which I do not include in the case file at this time. So I could get you that information after the session.
Anybody else have questions, Sam?
Not at the moment.
And then I did want to just quickly, I know you have it in your packet, but I wanted to kind of show some of the photos that the applicant provided to kind of give you a visual of where this edge of the fence, or shed rather, is 12 feet away. So that, 2 feet roughly is in compliance. It's this corner that if the variance was not granted, would need to be moved about 2 feet and 10 inches. So closer to 3 feet in to be in compliance. There was some measurements sent to kind of show you just how far from the surveyor's mark certain things were. And this is kind of a panoramic view, if you will, of the whole situation, the concrete, the shed, the fence. Showing that there is a gate there. And then this is that top-down view that you saw, which, it's clearly by the GIS line, which by no means can the GIS map be used as a fully accurate, but it's accurate to within,
This one happens to be pretty close.
Yeah,
Okay.
this one, and having, you know, again, seeing the photographs where the surveyor's mark was there and it was clearly past the line, that's why staff is confident in saying that we believe that those features are over the property line.
Correct me if I'm wrong or misunderstand. The shed has to be 10 feet, but the concrete associated with it, they have to move, do they have to break it up, or is it okay where
It's gotta
it is?
be.
The concrete can be up to the property
About-
line.
that's what I thought.
It's not part of the
Hold on a
pool, it's
second.
not a full apron.
Yes, it is.
I mean, so I'm with you, trust me, but
We'll talk about that in a little while.
the way, yeah, and the way staff would look at it as, I think, this above picture might be a better visual here. I think we're considering this kind of
As a pool
decorative
apron.
concrete, if you will, as pool apron, and this slab is, we would not consider it a pool apron for the purposes, now, it's connected to the pool apron, one could argue that it's an extension of the pool apron in that regard, but I think
It's
that they're
paved to
clearly
use with the
marked.
pool.
And that, I'm sorry?
It's paved to use with the pool. And if you notice, the shed is sitting on the same type of concrete or pavers as what's around the pool.
Hmm.
Okay?
No.
Just keep that in the back of your mind for now. And we'll get the input from the public, and then we can talk more about
Okay.
that.
Excellent.
We might be looking at another variance, because
Possibly.
we've granted those before, also for some pools over
Pool
in,
aprons, yeah,
yes,
yes.
so,
Okay,
okay?
and then, yeah, this was the, notice that went out to Dayton Daily News as per ORC requirements, so.
Okay?
All right, any other questions for me about?
Not at the moment, not to me.
In that case, I'd like to open up to the public and have people speaking for the variance come up, please. State your name. and-
Well, yeah, for,
Yeah, for, yeah.
yeah.
Well, I'm Sean Smith, 1778 Ash Meadow Court. We'll read that now.
Please, Dad, please.
I, Sean Smith, 1778 Ash Meadow Court, solemnly swear that the statements I'm about to make before Beavercreek Township Board of Zoning Appeals are the truth to the best of my knowledge and belief. So why express in my mind, we can go back to that picture.
Which
of
one,
the-
sir?
The whole, lot.
Aerial of the
Yeah.
patio, or
So you go back to the,
the other way,
Oh,
there.
you want this one here, up one, yeah,
yeah, right there.
all right.
So your apron is that walk around the pool, it's roughly 3 to 4 feet, not the pavers. So your apron, when you do a driveway at home, you got an apron that connects to the road. A lot of times it's concrete, connects to concrete. That don't mean your whole driveway's an apron. So typically when a pool company gives you a pool, that apron that goes around there is what's included. They don't do the pavers, they don't do none of the else. The shed's sitting on concrete, not pavers. So the pool, or the basketball court, is a painted concrete with a stripe and everything. That's why it kind of looks different. But the shed is on concrete, not pavers. So, guarantee you. I promise you.
Is
It's probably in the other pictures.
Is
you
the
can
concrete
see.
under the shed painted?
No.
Why is it brown like the pavers?
Well, can you go to another picture, maybe you can see it better? That's concrete.
Okay.
Hang on, there we go. Yeah,
Concrete.
that's hard to,
Yeah, it's hard to
Yeah.
spot.
The pavers
Huh.
are around the apron of the pool.
All right, it just brings up some questions. That's all.
Yeah, but
That we'll have for
just so
later.
your general knowledge, we don't necessarily go by the definition that contractors do when we determine structures and things. So just because the contractor says that's the apron, doesn't necessarily mean it meets the criteria for the code. Just so you know.
Right. But typically, that's what it would
Oh,
be.
yeah, that's what they
Yeah, there's no
say.
defined
Well,
width for apron.
Right.
Yeah,
so anyways, and another point up there, the corner of the fence is out 2 feet or so, not the whole fence row.
Right.
Another thing on the landscaping bed, actually landscaping for them, not us, we can't see it. I'd have to go in their yard to look at it. So that's for them. It's to make it look good. So that's just another point. But anyway, the shed, that would be a major cost. We'd have to tear down quite a bit of fence, get a piece of equipment in there and move the shed. It ain't something that you can get a couple guys and push it back. That ain't gonna happen. So it would be a big cost. It's not an eyesore. It's not endangering kids. We're not bringing more traffic into the neighborhood because of the shed. And I agree, it is not 10 foot away from property line, but it's been there 20 years. So we were told, we don't have proof, the shed was built when the pool was built, when all the fence. So all that you see back there was original owners, been there almost 20 years. So it ain't something we decide to do on a whim and just put it up. So I guess that's all I got to say, but I think we all know why we're here. It ain't because of that fence. It ain't because of the shed. We know why we're here.
Let's just please
Yeah, but
stick to what we're talking about. Don't bring anything in the past up to it, sir.
But the shed's not an eyesore. It's not hurting anything they could possibly want to do.
Okay, had I read somewhere where you were in agreement to move the landscaping there by the driveway, or not?
Well, originally, before I got a letter from his attorney, before I got the letter from you guys, when I seen the survey stakes go up, I'm like, that's weird. Because I didn't know either.
Right.
And I asked him across the drive, because they wouldn't come over and talk to me. I was like, hey, if you want this moved, I'll move it. That was before I got the letter from his attorney, and then your letter, and I'm thinking, did he come over and ask me?
Right.
So this is where we're at.
So is that landscaping there?
It's a landscaping bed.
Is
It's
it-
got some rocks in it.
Will that be a major thing to move, or not? I can't remember.
I'll have to get a piece of equipment to move the boulders.
There's some boulders there?
Yeah.
Okay.
So the driveway sits up,
Right, okay,
and so the elevation change is probably 3 to 4 feet.
okay.
So the boulders build the driveway up.
Right, how far out would you say that protrudes there, the boulders? How far would you say that is into their property?
2 to 3 feet.
3 feet max?
Probably. Yeah, that's a guess. I never measured that.
Okay,
But that's really landscaping for them. And they originally built that up for the elevation of the driveway.
right.
So it's not gonna be an easy thing you just can't remove the boulders. I mean, there's gonna be some work, there's gotta be equipment brought in
Right,
to
right.
do it.
Okay, I get,
Okay.
you said that one of the things, and I fully understand where you're coming from, is the cost of what you would have to do to move it. But then you turned around and said, well, you're gonna have to bring special equipment in to move the rocks, okay? You're gonna have to take part of the fence down anyway to get it off his property. So if you had the equipment there to move the heavy boulders, why couldn't you have it there at the same time to move?
Well, if you make me tear down the fence, or move the fence back.
We have no say on that. We cannot, the fence is on your neighbor's property. That is nothing, we cannot give you a variance that encroaches on somebody else's property. We cannot do that. It's, no way. So,
Anyway,
that's between you and him.
If I move that fence back, that, as you can see, it's on that corner, it ain't up front by the shed.
Right.
I would need to tear down in front of the shed and just shove that back, not bring the equipment. So the fence, you don't need equipment to remove.
Understand
The fence
that.
guys will. The equipment would be over for the boulders, is all.
Right.
And you said you would need heavy equipment to move the,
Different type of equipment. You'd use a mini hoe for the boulders, excavator,
Oh, yeah.
that you would need a bobcat or a roll to push it back, and then you'd have to take down the fence in front of the shed. So two different pieces of equipment, two different types, so. I think that's all I have. Do you got any questions for me?
Oh, we'll probably have another one here
Okay,
before
thank
we're
you.
done, thank you.
Appreciate it.
Do we have anybody else that wants to speak? Or the,
There we go. We got a customer.
I, Brian Wyrick, Brian Wyrick at 1824 Ash Meadow Court, solemnly swear that the statements I am about to make before the Beavercreek Township Board of Zoning Appeals are the truth to the best of my knowledge and belief. Okay, so I live 2 houses down from the Smiths, and our property line also borders the Smiths property line, and so that means every time I drive down the cul-de-sac, I do see the offending shed in question. And from the back of my yard, I'm able to have direct line of sight, and so I can see it when I'm working in the back of the yard too. We've been there several years, and I've never had any issues with the shed. I feel it looks fine, it complements the property, feng shui, everything seems to line well. So I just want to say on record that I have no problem with it. It wouldn't injure me to stay where it's at. And additionally, I don't see how moving it would, or shifting it, 2.5 feet to 3 feet would really change the nature of where it's at. That would, not injure the party that's complaining about it, so. Yeah.
Okay.
Thank you.
All right, thanks.
Apologies, Board, that's Brent. Apparently went to the front door in like the couple of minutes between when you had come in, and so we kind of just missed him. He's all right, so just wanted to let you know, that's why you weren't able to make it. Apologies for the interruption.
okay, go ahead.
Oh,
Hi. I, Donna Waldron of 1816 Grand Portage Trail, solemnly swear the statements I'm about to make before the Beavercreek Township Board of Zoning Appeals are the truth to the best of my knowledge and belief. I'm actually on the homeowners association. I don't live right next door to the Smiths or the Stags, but in any event, we did receive notice of the hearing at our address, so that's why I'm here. I do fully support Max's recommendation of granting the waiver for the shed. I do want to point out a couple things, though. I understand that the zoning board can't do anything about the property line. And I just want to make sure that the Smiths understand also that there's case law in Ohio about property lines and what's called adverse possession use of land. And there's 5 different criteria that you need to meet in a situation like this where your fence is on your neighbor's property in order for you to be able to keep your fence on the neighbor's property. And those 5 criteria are: it's against the right of the true owner, which in this case would be Mr. Staggs, if in fact he is the true owner, because there was not an independent survey that was done of the property. So it has to be against the right of the true owner. It has to be an actual violation, which it is, just that corner you can see. It has to be exclusive to trespassers, which is the Smith family would be considered the trespassers in this situation, and it is exclusive to them, it's their fence. It has to be out in the open, which it is, it's out in the open, you can see it, and I'm not hiding it. And then the 5th thing is it has to be continuous. And in the state of Ohio, 21 years is considered continuous. What we're talking about here is 19 years and some odd months, so we're very close to that 21-year mark for continuous use of property. And there's case law from a case in Elyria, which is over near Cleveland, where this exact thing happened between 2 neighbors, and the neighbor with the existing fence prevailed. And the neighbor next door took it not only to the 9th District Court of Appeals, but also the Ohio Supreme Court, and still could not get that fence moved. So given the fact that the fence is 19 years old, and the fact that the Smiths can meet every other of the 5-prong test for adverse use of the property, I don't think it's fair for the zoning board to grant the exemption for the shed on the condition that they move the fence. I think the fence moving has to be something that takes place in court.
Again, to make everybody understand and clear, the only thing that we can give a variance for
Right.
is the shed.
I totally
It
understand.
have nothing to do with the landscaping over the fence.
I understand, but Max's recommendation is that you grant the exception for the shed on the condition that they move the fence. And my
I
point is
don't-
that I don't think there should be a condition for moving the fence because you guys can't do that.
No, we can't.
But I also want to, Max, can you go back to the photo, the landscape photo that you had of the Smith's backyard? Yep, right there. Okay, so you're looking at the Smith's backyard, right? There's the shed, there's the fence that juts out, and we talked, one of you guys talked earlier, I think it might have been Max, about the cost involved. There is a cost to the complainant, which is the Staggs family. There's a cost to the Smiths. The Smiths have an actual out-of-pocket cost to move the shed, move the fence, whatever they have to do, in order to comply with what the Staggs are asserting. But the cost to the Staggs is subjective. It's, okay, they're offended when they walk out the door and see the shed on their property line. I totally understand that, or it's too close to the property line. But I want to point out in the background, the Staggs put up a 6-foot fence, a 6-foot privacy fence that runs across their backyard. So if they're in their backyard, the Staggs cannot see the Smith's backyard. So if you go back, Max, to the other picture of the property line, the aerial picture. Thank you. You can't see the Staggs fence there because it hasn't been put in yet. But the Staggs are only seeing that corner of the shed when they're pulling in and out of their driveway. And again, I would just say the cost to the Smiths, which is an objective cost versus the cost of the Staggs for moving that shed, I would encourage the zoning board to grant the appeal for the variance. Yes, thank you for that shed.
I want to thank you for bringing the fence, privacy fence up. That's something that, obviously, when we look at that, we can pick up. Thank you.
Okay, you're welcome. Anything else?
Thanks.
You're welcome.
No.
I, Olivia Beal, 1876 Pathfinder Court, solemnly swear that the statements I'm about to make before the Beavercreek Township Board of Zoning Appeals are true to the best of my knowledge and belief. The only other thing that I'd like to point out in this case is that the Staggs recently moved in. They could have chosen to say that driveway, that fence, that whatever is too close to my house, I don't like it. So to move in now, and then move in a year ago and now say, gosh, it's right on my property line, seems a little suspicious or odd, I guess. I wouldn't say suspicious, but odd. And they did put up a 6-foot wooden privacy fence. There's nobody seeing through that for sure. So I don't think that it constitutes injurious treatment of them by their neighbors, the Smiths. The last thing I would point out is that I know, Max, you said you have the permit back in your office. You didn't bring it, the original permit for the fence and so on and so forth, but I happen to have seen a copy. And it was in August of 2003. And frankly, I think if this board is gonna say that the board 19 plus years ago did it wrong, I think you're opening up yourselves to a huge can of worms in terms of other potential violations in the neighborhood and around Beavercreek Township. So I would caution you against opening yourselves up to that.
So is that a threat?
No, not at all. I'm just saying, I can go walk my neighborhood and find other violations if I want to.
We
If I
can
was that
find
neighbor.
violations
I'm
everywhere.
sure you can,
And-
but
We're willing to take them on.
my
We're
point
here
is
on-
that,
Hold up. We're getting off
no,
case
my
now.
point was simply that if the
And-
board approved it 19 years ago, why would we go
Ma'am,
change it now?
You're making an assumption that it had to come in front of the board, number one, which I bet it did not.
It has signature from the township board.
It's one thing, not
You mean when they
necessarily,
got the permit?
when they got the permit, not
Mhm.
necessarily
Well,
for
that's the
these.
zoning department.
See,
They come before
and we're getting off base here.
Not the board with-
My point was just that it got approved 19 years ago. I think it's silly to go back after it now. Right or wrong, I think it's silly. That's it.
Okay, also keep in mind what I said in the very beginning of the meeting. When you apply for a fence permit, it's a hand-drawn,
I get it.
dotted line where you're going to put your fence, and the Beavercreek zoning department, just like the city of Beavercreek, takes that at its word. They do not go do a survey. They say that if there's ever an issue, it's between the two owners.
I would,
Because you put down here that it's gonna be on your property line, and it's not.
I would
so-
argue that before you do a variance of any kind, you don't rely on one homeowner survey and you maybe get a third-party independent survey. Recognizing there's a cost involved in that too.
Okay,
Well, thank you for your opinion.
There-
thanks.
I just wanted to clear up that, and I think you may have mentioned to it, that the original permit had no involvement with the BZA. It was granted as just a standard permit. It did not require variance at that time. I will also give you some information that what was originally submitted on the permit is quite a bit different from what was actually built, by a significant amount. So while I can't speak to the practices of the office in 2003, I wasn't employed here, I will just point those things out about this particular permit.
Yeah, we're not here to make judgment, change anything from the previous, that's not what this is about. This is about resolving something that just came into to knowledge.
Question, Max, was there a professional survey done on this to establish the lines?
Not initiated by the zoning department. We can't independently verify through the.
Understand it, was there a professional survey done that brought this to light? Or did somebody just happen to look at the GIS map and say, oh,
It's my understanding that the Stags had a surveyor, a licensed surveyor, coming before you,
Yeah,
sir.
we'll be able to
Okay,
get
we'll
that
find
when they come- when they
Okay.
come up. But to get on that, so you people know, we're not here to establish new facts, okay? And you brought up that, hey, we should not just take one survey. That's fine. It's not our responsibility. We have the survey that was done. If somebody wants to challenge that survey, it would have to be the other party, not us. We're gonna go with the information that is presented to us at the time of the meeting from either the complaint or the person who wants it. That's where we are. Okay, now, anybody else wants to speak for it?
also you might announce that we do not set precedents in here. We do not. Okay,
Okay, speak against, please,
okay, again,
please.
I'm Randall Staggs. I live at 1800 Ash Meadow Court. Solemnly swear that the statements I'm about to make before the Beavercreek Township Board of Zoning Appeals are the truth and the best of my knowledge and belief. I did the survey. I did the survey based on recommendations from the pool company that's putting in our pool. They uncovered the original pins with the stamps on top of them and left them out and took pictures and did it professionally the way that they're supposed to. I don't know the name of the company right off the top of my head, but I can pull those records.
so you're saying you hired a
I
surveyor? Okay,
I
you
hired
said you
them.
did, okay.
No, I didn't.
You hired a surveyor, okay,
They showed me
Okay.
where the pins are
right.
and told me exactly what was going on and so forth.
Okay,
The shed is a beautiful shed. I've never had any problems with the look of the shed. It is the position of the shed that has been a concern of ours. Back in March 16th of this year, when we appeared before you, the Smiths stood up and under oath told you they're moving. They're selling the house. So any agreement that they might have as far as not placing any chemicals or explosives inside this shed, which is 33 feet from my parking area where that car is sitting and 57 feet from my house, will be dangerous to my family. They can't guarantee that the people who buy the house from them will make sure that there's nothing dangerous in that shed. I've talked to Max to see what the zoning is and what chemicals you can put in these sheds, and there is no guidance for this township on what you can place in your sheds. Flammable chemicals. The next guy that comes along might be die-hard military, decide I'm gonna put my MRE heat tabs in there, and I don't care what anybody says. It is too close. We feel unsafe at that point. There's still another acre of lot there growing grass that the shed can be moved to. I have no problems about the, what you consider an apron or not an apron, as long as it's right at the property line, concrete go right up to that. We do have plans for our property line, that's why we even started looking at this as far as what we were gonna do to the edge of our property line, and would like the boulders moved, or I'll move them. Any questions?
Yeah, you do understand, by looking at how the shed's laid, that the back half of that shed is 12 feet, so it's 2 feet past the 10-foot requirement. So if they rotate that, they're only gonna rotate just, I don't know, my geometry is,
Well,
Pat said.
one corner would be 12 feet off the line, the other
Yeah.
is 7 foot 2 inches.
would be, about what I'm saying, he's complaining about the chance of
2.5
exploding.
feet.
You move that 2.5 feet, get it back at 12 feet, you're not changing the distance of where the shed is sitting right now. It's going to be sitting the same place, only it's going to be rotated 2.5 feet. So your concern about it exploding to be, you know, you need.
You could have explosives in your house that could wipe out half
You
the
know,
neighborhood.
Because we can't force him to move past what,
I
It's
understand,
stated.
I get what you're saying. Any inch, any foot is survivability.
but you're not, that's what I'm trying to say, you're not, that front half of that's 7.5 feet off of the property line, probably will not hold enough explosives to bother you. The rest of it, that's anywhere from 12 to 7.5, is if it's full, that's a different story, but we can't.
So
The
it's not
township-
necessarily
the
just
township is-
explosives or anything.
the township does not-
It's a mixture of chemicals.
Have any authority on what someone stores in their shed?
I
No
understand.
one.
That
Okay.
is why I asked for the full 10 feet, give my family extra chance.
Think that'd make a difference, huh?
I've been in an environment where an inch always makes a difference.
Okay.
Okay. Any other questions?
But I understand that the variances are here for you to have the ability to move up and get to the property line, but I'm pretty sure that was the intent of the idea was both parties agree, because you're infringing on the other party by saying, we're gonna put it at the property line. He can go within the 10 feet.
We take in consideration,
That's to be discussed.
yeah.
How's that?
Yeah,
When we
that's,
close a meeting, that's to be discussed.
and we take in consideration all properties and the effect on all properties.
Right.
But, and it's something that we stated in previous hearings, we tried to take into consideration the owner's use of his property. And I know that's hard for you to swallow, given your history with this. But that's just the way we have to take a look at it.
Something else to consider is the house that I'm in wasn't built in 2003. It was built in 2006.
Okay.
They infringed on the property because they knew nobody would care.
Well, that's.
Well, you thought it would have been caught when they went to build the house.
Yeah, that's a different statement.
You would have thought that someone would have seen,
Okay.
did a survey so they could place their house on their lot and would have said, hey, look here,
Yeah, when they first staked the lots out.
for the 2006 house,
Absolutely.
you know?
That's not necessarily a
You think they just-
communication that the contractor does with
I
the
agree.
purchaser. I've had houses built and they don't tell me nothing. They say,
You just
we're
said,
gonna go with this and go
you
with
just said
that.
your-
Here's your house, how do you like it?
you just said your future contractor showed you where the pins were at.
No.
The surveyor showed you where the pins were at, and that your contractor, with whatever you're getting ready to do, wanted you to get it surveyed, so that whatever you're gonna do isn't put in the wrong spot. I mean, we had a case over in Country Club of the North where they had to move the brand-new pool.
Yes,
They
sir,
didn't
I'm
tear
not
it
trying
down.
to interrupt you, but the property there is built into like a little valley.
Yep.
He wasn't just surveying the property lines, he was surveying my drainage. Because the drainage has to come off of that pool and go to the front ditch. Or bypass my septic tank, which is on the other side of the house.
You're gonna drain you're
No,
gonna
not
drain
the pool.
The
rain.
groundwater.
The groundwater has to be moved away from the pool. As it stands, they're gonna put the pool 3 feet high, just to give it the proper clearance that needs for drainage.
Yeah, that has nothing to do with what we're talking about now.
But,
Okay.
Anything else?
um,
I don't want to,
no, I think that's it.
anybody else have any questions? Anybody else want to speak against?
No, for, or against, I'm
Yes.
sorry.
Okay, with that, we're going to close the public part of this hearing, and we'll discuss it between the group. Why can't we ever have something a little bit less complicated than we're doing now?
Right, so I was concerned about the adverse possession, because you know I'm a lawyer. And I know we can't make any determination regarding property lines. If it's 19 years though, and the statute says 21, I don't know that that would work, because I don't know, and I'm not gonna make any kind of judgments, because I haven't researched it at the moment, whether or not they can vary at all from that. My gut tells me they cannot. So if there was an adverse possession thing, I think we would have to have an issue, potentially even reaching out to a court to make a decision for us. Because if the property line was by law taken on because of adverse possession, they would not be in violation because their property line would have been extended.
We would have expended that.
But I
3 feet.
don't think, because it's 19 years instead of 21, that it would apply. I don't know that for sure. I only know that when I've studied it for the other states I've been licensed in as well as this one, I do believe that's the case. Now, that being said, I don't think it applies here, but I have not researched it. But that would change the property line, which means it wouldn't even need a variance.
And again,
I know, I don't,
that's outside.
I know
of
it
our-
is.
So we're not quite to the,
so I don't think that we have to deal with it because I don't think it's hit the 21 years. But should they all retain lawyers and deal with that in court, then it would change our opinion.
so our discussion's not on the fence, they gotta move the fence regardless.
As far as that's between the two,
That could become a civil issue.
yeah, that's
It could be.
between the two
Okay.
property owners.
Which means I
what
don't-
they want to do.
Okay.
I don't think we can handle this
Any
with the fence moving, can we then?
No.
So I don't think we can handle that part of the
I
recommendation.
was going to scratch that out as one of the recommendations, because we cannot,
How about the landscaping?
same thing, anything that's on your neighbor's property, we have no say in what happens.
Okay,
We cannot,
Okay.
cannot give the neighbor the right to encroach on his neighbor's property.
Right.
That's-
Right.
you Flat out can't do it.
or tell them not to.
Or
Right,
tell them, we
Right.
can't, that's between the two property owners, how they want to work it out.
Okay,
You know,
so anything we're talking about, so there wouldn't be any conditions if we approved
that's correct,
right.
the building in question.
right. Yeah, absolutely. Now,
Now, are we looking,
yeah, there's a lot to this. First of all, there's no way they knew when they bought the house that the property lines were where they are. So are we looking at, I mean.
well, other than if someone would have taken the time to look at the GIS map, which we're looking at here, it would have showed that, but
So
obviously it didn't get looked at it.
Yeah,
I,
and-
I think no matter what the property lines are, that's more of a civil issue that they'll have to discuss.
Right.
But if we take it as is, it's just whether or not the 2.5 feet is so injurious.
And,
Right.
and
That's what I think.
And that's, you know, usually when we take a look at making a decision on impact, of course, there's, does it drain the wrong way? You know, I mean, a lot of things, is it impacting the neighbor's property and how is it impacting it? With a privacy fence all the way around it like they get, they can't see the backyard. So the only way they can see it is from when they pull up to their driveway.
Well,
So I'm not,
That's really not,
Right,
because I can
I'm
look
not-
over a 6-foot fence.
I'm not really sure if that's,
If it was an 8-foot fence, I'd agree.
and if we have them move it, I'm gonna make a guess. They're not gonna pick that whole thing up and move it, they're just gonna rotate it. So one end is still gonna be 12 feet, the other one, they move it 2.5 feet. I can understand their concern about safety, but I don't think it's really there. I don't think it's gonna improve by rotating it around 2.5 feet. I don't see where that was gonna give him the safety that he's looking for.
So on the variance, it would be granted, if we granted, it would be just on the shed, and then the removal of the concrete point is a civil issue between the two neighbors. And the landscaping is a civil issue between the two neighbors.
Right.
They can either agree to remove it or not agree and go to court, or,
That's
And the
right.
fence issue,
okay, and the fence issue is
civil.
The
civil.
Yeah,
only thing we're looking at,
Right.
only thing we're gonna.
What, but the fence had a permit granted for it, so we should be able to say you move the fence.
I think we could, except that I don't
We
think,
should be able to say move the fence.
I think we can too, but I don't think that it's the subject of the hearing.
It's not.
So I don't know that we can determine something
But it
that's
can be a
not been.
condition of,
I understand, yeah.
if we were to grant the variance for the shed, we could say, and move the fence
Right,
at least to the property line, correct the fence to the line, and then the concrete that's remaining, so we kill two birds with one stone.
right. Well, and I get that, but I also think that it might not be a good thing to do, to go outside the parameters when we don't have evidence of the original or any of that with us
I-
here. It's like making a ruling on something we don't have evidence of.
I have,
On what?
The fact that we don't know where the permit said back then, we don't know what would need to be changed, we don't know whether or not there was or was not a survey. I would fear that we would be making a judgment on something we don't have evidence for.
Well, that's irrelevant. We're looking at existing, what's there right now. The fence is on his property, the concrete under the fence is on his neighbor's property, the landscaping in the front's on his neighbor's property. We have no control over the landscaping, we have no control over the concrete under the fence, but we do have say-so on the fence, because we granted the permit. And as I stated before, the township does not go out and physically examine where you're gonna put your fence to verify that you put it in the correct position. They strictly wait on the neighbor to come in at some point in the future and say, hey, that, part of that fence is on my property.
that's where I got
So-
earlier, is that if there's a challenge to any of the surveys, whoever does it, it's up to the person who's doing the challenge to make arrangements to get another survey done. It's not-
Well, yeah.
It's not our responsibility.
No, it's not. If they're both in agreement with the survey that was done, which it sounds like they are,
But getting to where she was going, if he did a survey and found out that the one survey was incorrect, that the way the fence is right now, then they're another 3 feet off the property line, so they're well within the 10 feet. Because the property line would be where it is, where the fence is right now.
okay, my only question is this.
But we can't do that because we don't have two opposing surveys. We have to go with what. the
Correct,
survey does.
but we all agree that the fence is on the neighbor's property,
Going by the latest survey, that is correct.
which was professionally done.
Right, and that's the one we have to build.
So I would think another professionally done survey would be ditto of,
They only dug up the pits.
right, and then what they do,
They just dug up the pits.
I know, did the surveyor line of sight it, or did he put his,
I
He
don't,
does.
I don't think we
Thing?
know.
We don't know.
You're shaking your head.
He has those tripod things
Right.
with these things on there, and he went along spray painting the grass with orange paint,
okay.
Oh,
putting stakes
Okay.
So we
in.
did do that.
Okay, so
So
it was professional.
Okay.
So I think that we can make a condition to put the fence correct and leave the shed where it is. We've granted variances for sheds a hell of a lot closer. We've granted them 1 foot from the property line.
I'd be in favor of doing the variance, for sure. I don't think we should touch the fence. I think it's outside, and if it needs to be brought as a separate case, sadly, that's what'll have to happen. But I think that if we make them move that fence, if there is a case about adverse possession, you know what I'm saying? I think it gets in the territory we don't need to do.
There can't be they cannot request a variance to keep the fence where it is. They can't do it.
Right, no.
Because they're asking us to give them permission to keep the fence on the property line.
I can guarantee you.
On their neighbor's property. So,
Sure.
which we cannot do, so there,
Right. No, I understand what you're saying. I just don't know if there is going to be a property line dispute, and that's
Yeah,
where
that-
the problem lies.
yeah.
I
If
think
we
they're both-
address it and there is a problem.
Are you both in agreement with the property line?
I didn't have a survey done, I haven't seen the official survey. I mean, anybody can go out there and paint lines, I mean, how many construction, so I know.
Okay, have you seen the pins that have been located?
No, I've
Have you
seen the
them?
wood stakes,
Pardon?
the wood stakes.
And so
You haven't seen the survey pins that,
The metal pins in the ground?
I didn't go look for the metal pins. I just seen his wood stakes by the fence.
please,
all right.
let's make a couple of things clear. I do not want to sit here as a board and start getting an already violent neighborhood situation and make it worse.
With
Yeah.
what?
By getting two neighbors even challenging now, is the survey correct or not?
I strictly asked,
I understand.
are they in agreement with the
And
survey?
I fully understand that, and I'm taking a look at the
And
body.
he gave an answer, and he gave an answer. I didn't look that there was anything vicious between them.
Well, I just don't want to start and keep focused on what we have to do. We have to trust the survey is correct. That's the only thing that's been presented to us.
Right, and I can guarantee you that when the hand-drawn fence application was submitted, clear back in God knows when, okay, 2002 probably, and it was built in 2003, or granted in 2003 and was built in 2003, I can guarantee you that it didn't show a dotted line going on to the neighbor's property.
No, and
But that's where the fence ended up. So the fence is related to the application from the zoning department.
I'm not.
We should have the authority to say, move the fence back to the property line and leave your shed where it's at. I don't think the fence is a separate issue. The fence is tied in right now with the property line dispute, with the property line issue. We can't tell them, it's between the two of them to take that piece of concrete off that's under the fence. But I think we have the ability to say, move the fence. It's not conforming. It's not to what the permit was back when it was built. Even though they didn't build it, it's now been brought to the attention of the new homeowner that there was a professional survey done and all these things are on our property. And of course, that property owner next door is saying, I want everything moved. You know,
Which is his right to do.
it is.
and it is, but we're sorting out here what's a civil issue and what's an issue the BZA can grant a variance for or not.
And we walk in a thin line on that, because as you know, anything that we rule on is subject to appeal, everything.
I understand that.
So
So-
we have to make sure that we stick to as much as what our authority is and what we're allowable to do, and now we are.
I understand that.
Can we require they move the fence as part of the variance?
So after having heard, especially Ms. Gottwald's comments, staff, I guess, now in the absence of legal counsel, in the absence of township legal counsel being here to give us more guidance on that, and none of us are attorneys, the only attorney in the room is sitting on the board. I think staff's position now would be that we should indeed focus on the variance for the location of the shed. And the rest of the issues, while staff tried to broker a compromise, if you will, with these conditions, I think what's come to light has changed my opinion on whether or not that's possible. And since we don't know for sure, we should not forward those waters for the chance that
We do not know what's for sure.
we do not know for sure if this board has the authority or ability to require them to move the fence off of their neighbor's property.
If I come in and get it filed, give you a permit for my property, and I hand you what's required, and you grant me a fence permit, you then, as the zoning board, have 100% power to go out and say, you got that on the other people's property, you need to move your fence.
I don't.
It's that simple.
So I don't disagree with any of that. I don't disagree that we have the authority to do that with fences. My fear is that it's not the subject matter of this. The variance requested was a shed. Nothing was requested regarding the fence.
So
I
I'll
don't think that we can
I'll make a
handle.
motion that we,
I don't
I don't
know-
think we can
yeah, I
though,
don't-
because of public
Only
hearing.
the applicant, I believe, would be able to modify their request. And I don't believe, again, I would have to check with Don, our legal counsel. I don't know that they can do that mid-hearing either. I believe they would have to initiate another case if they wanted a variance. But again, that's a variance we cannot grant.
We can't grant it. We
a
couldn't even
fence is a
consider.
zoning issue.
But as,
Period.
but as John explained, there's no way, if the variance was, hey, my neighbor believes that this fence is on their property, I believe it's on mine, and I'm seeking a variance to allow it to remain, even if it is on neighbor's property, we cannot grant that variance.
Can't
There's
even,
no possible way.
They had a survey done. Professional surveyor. I don't have the results in front of me.
Neither do I.
Can we put a condition on the shed, and the condition be, make the fence conforming? That's the end of the conversation. We're not involved in anything else.
I mean, that was what staff was attempting to do with the conditions that were suggested. Perhaps they were not worded in a way that allows them to be good conditions. But again, we're lucky enough that one of the board members is an attorney.
I am not giving
And I
legal advice.
understand.
Make that very
That's been
clear.
called-
But not that
Make that very
but she
clear.
is indeed saying, hey, we should be wary of these issues. And I think that's.
Wary of, but I'm missing the point here. Wary of what? We're not telling them to move the boulders. We're
No.
not telling them to move the concrete that's sticking over into the property. We're saying the fence is in the wrong position.
No, I don't disagree with you. I think we could. The issue is whether we can make a decision on something that was not publicly provided to get evidence on a fence. We were only supposed to be handling the shed.
No, but we can put any condition.
We
want.
can, but can we also put a condition on a roof if we see it when
But
it
when you-
involves the shed?
On the what?
Yep.
Can we put a condition on something else when we're only supposed to be having a hearing about a shed? You know what I mean? That's my
Well,
question.
you're saying there
And
needs to
I
be a
don't-
separate hearing for the fence?
I'm saying there
And
might,
there-
and I don't know the answer. That's why I'm saying I'm concerned.
there can't be. All
But,
right?
no, and I get what you're saying too.
There absolutely cannot be a variance hearing for the fence, because we cannot take another person's property and give it to somebody else. And in essence, if we have an agreement that we can leave the fence where it is.
No, no.
No, please hear me out. All right, you're absolutely right. What should happen is they should make a complaint to the zoning people that the fence is in the wrong place, and then it would be up to them to turn around and say, hey, you got the fence in the wrong place, it needs to be moved, or do it on the civil aspect. It's
Okay.
not something, it's not something here. It's not within our realm of authority.
Why? Because it wasn't posted as a fence
That-
variance?
No, because they couldn't post it as a fence variance. Leo, that's what I'm saying. It's not a.
Right, we can't grant them a fence variance.
It's not a
So,
variance.
so then that comes back to my point, full circle. We can put as a condition that they move the fence.
When he
Yes, we can.
When he submitted this variance request, he sort of said, I agree with the survey,
Right.
which means he agreed that his fence is in the wrong place.
And we heard from the beginning that both they agreed that the fence and the landscaping has to be moved.
Right, but we in discussing, have no control over the boulders and the landscaping and the concrete. But this board has control over fences.
Because we provided that.
We provided the fence permit.
The zoning.
That puts us in the ballgame. Because what is the fence permit? It's supposed to guarantee that you're putting that fence on your property. Okay? If and the zoning department only goes out if there's a complaint or an issue. They don't go out looking to see if someone's fence looks like it's over on somebody else's property. They don't have time for that.
But let's
But
take,
when it's brought to the attention that, hey, the fence is in the wrong place, the shed's too close to the property line, we have issuance of those two items. Nothing else is on the wrong property.
please, most of our fence authority to issue variances deals with height and type of material.
Right, because we can't grant a variance to have it on somebody else's property.
So why, you see what I'm saying?
Well,
We're going a circle argument
I'm not,
that is going to have to be settled between the two property owners on what they want done. If the property owner that is being,
John, I'm not saying that they're in here for a fence variance. I'm saying they're in here for a variance on the setback of the barn.
right,
As a granting of the variance for the barn to stay where it's at, we put a condition on that to put the fence so that it's conforming. We're not saying leave, as a condition, leave the fence on the other person's property. We're not saying that we're gonna grant you a variance to leave it on the other person's property. We're saying make it legal and put it on the property line as a condition to us saying, we'll let your barn stay where it's at. This is our only chance to get that fence moved. This is our only chance to get that fence to come into compliance. Other than the two neighbors arguing back and forth and taking each other to court to get the fence removed, which is our responsibility. We granted the permit for it.
I don't see where it's the responsibility of the zoning appeals board to do that. I do not.
Mr. Henry, Mr. Thomas, I think if as the board has some issues with it, obviously we can contact the Township Legal Counsel in regards to that, and get a clear definition. That's the only thing we can do unless you guys come up with some kind of decision.
That,
would we be
How to go
willing,
forward.
would we be willing to pass a variance without a condition? I'm assuming no.
I want the fence moved. And I think the only way you're gonna get the fence moved is to put it in the condition, as a condition for leaving the barn as it sits.
I suspect that if they do not choose to move the fence, they will be sued civilly.
yeah.
I suspect that we don't need to make a ruling on that.
I would, and
You're looking
again,
into your crystal ball now.
and again, we,
Well, that's up to them.
yeah. Yeah.
I know we have the authority to put things on fences.
So when someone gets a fence permit, we don't have any control over or any say-so as to if they build it 5 feet over in the neighbor's yard and someone and our zoning department drives by and says, oh, that's clear over on their property.
Mr. Henry, you have to understand, we tried to the best of our ability as staff to go out and verify the placement of fences as the fence companies provide them. This case specifically came up in 2003,
August, yeah.
which was the
Right.
time that Greene County had the zoning for Beavercreek Township. So they were dealing with it at that time. It was not specific. Now, obviously, we're taking this on, but again, I'll get to the point that if there's an issue and you as a full board member do not make a motion or make a motion and accept that motion, whatever, I think if we deal with the property line, we need to have legal counsel, our legal counsel, give an interpretation.
Well, then we can't do anything because we're dealing with the property line on the placement of the building.
There is an option for the board to, table this or say, hey, look, we need more information, we need more facts. And based on the discussion I've heard, that may be the case. It may be that we need to, bring in the original permit. Perhaps we can request the survey results if that's something, but again, I don't know if that's where we want to be.
I'm not sure for the request for the variance. And again, to your point, sticking to what has been requested for us. And that is, do we give them a variance to keep that corner of the shed 7.5 feet from the property line? That's the clutches of the variance. Now, everything else was brought forward. You could have presented this without even saying anything about the fence or the landscaping, and that's all we would have been dealing with, is just that. Just
No, we would have brought the fence up. I guarantee you, it would have come up in our discussion.
But focus, the question is, that is what is on us now. To your point, Leo, if the fence and the landscaping gets moved or doesn't get moved, I understand what your point is, but it's between those two people.
The fence is non-conforming. The landscaping is an issue between the two parties. The fence is non-conforming to the permit that was on file. You agree with that?
And that's our jurisdiction.
Yes, exactly.
It is, but doesn't it have to be brought before us?
No, because we can't grant a variance, yay or nay.
Okay.
You see, and that's-
I'm not trying to get though.
No,
I just-
no.
This is our only chance
You know what I
to
mean?
have it, this is our only chance to have any teeth in getting the fence moved. The rest of the issues have to be dealt with between the two parties, the two property owners, either mutually agreeing and getting something done, or one's gonna take the other to court. The fellow that has the stuff, the property owner that has the stuff over the line, he's not gonna take the neighbor to court to keep it there. He's gonna sit back and wait and see if, the neighbor takes him to court before he probably acts on it.
If that's the way it goes, that's the way our legal system works.
I guarantee you that
Yeah.
that nowadays, when he goes to sell this house, if he's supposedly moving, he's gonna have an issue with that fence being over on the neighbor's property.
Again, that's another issue.
I know that, John, but we have control over the damn
Well,
fence,
that's where we have it.
on the placement of the fence. We do, because you filed a permit for it. We have complete control over the placement of the fence. So,
Permit 20 years ago.
doesn't matter, it could have been 100 years ago.
Okay, here, as I'm looking at, here's our choices we're facing. One is table it to get a legal. The other is to sit down and get a motion and vote on it. But if it shows up 2-2, it's a tie, it fails, is that correct?
Yeah, I believe, yes, a motion that does not have a majority would therefore fail.
I'll make a motion to table, case 862.
Do I have a second? I second it. All in favor? Roll call, please.
Mr. Martinsek,
Yes.
Mr. Thomas,
Yes.
Mrs. Scott-Wold,
Yes.
Yes,
Mr. Henrik.
Okay.
We know it's due.
I believe that you, when you table it, need to present the date and time that it would be heard again, if I'm not mistaken. So I ask that you set that for our next regularly scheduled BZA hearing in September.
And you'll have the information for us from your lawyer?
I would request that if you are looking for specific information to help you make a decision, that
We
you
want to know if we can
outline
address the
that.
fence.
That's what I'm saying. I would ask, as part of this, that you would outline specifically what information I could bring you to help. And we, of course, will have Dawn, our legal attorney, present at the September meeting.
she should have been here today, but maybe she wasn't available.
That is unfortunately sometimes the case.
So the September meeting would be 9/21.
Just making sure.
We should be
It
back.
can only be us four again, we cannot bring in.
Brent would be able to listen, he could not vote or even discuss with you. I believe he would be
You
able
can
to.
add the discussion, you can add the discussion.
I would have to confirm with Dawn, but I believe the answer is no, actually. Yeah.
Okay.
So, I don't know when I asked you a question about what you proposed in here, do we do it after the meeting or right now, or? I have some questions on where you arrived at some of your things you thought.
My conditions that I propose, or?
Yeah, how did you arrive at those? Did you get any legal input on that, or?
No, we didn't have Dawn look at those. This is staff report. This was staff's attempt at, hey, what would represent a reasonable compromise. Staff, when variances are requested, staff typically looks for ways to grant them, reasons to yes, right? what conditions would staff be comfortable with being in place that would allow staff to be comfortable with the variance being granted. Sometimes there are no such conditions, and very rarely you've seen me recommend against a certain appeal being granted. But I think if you'll look back at the 2.5 years that we've been spending together, you'll recognize most of my recommendations are for approval with some form of condition. It's clear to me that in this case, the recommended conditions I've made are testing the limits of the authority of this board.
It is, absolutely is.
Well, we know it's testing the limits on based on what's been said.
You're asking us to do something that we don't have the authority normally to do. And yet, it gets down to who's responsible to enforce that fence gets moved. Where does it come into?
And I can tell you staff's response when similar property line issues are brought to our attention, which have happened a number of times in my tenure here, our response is, staff does not have the technical ability to determine where a property line is, and so staff cannot make a determination about whether or not a fence is over a property line. So you must resolve the property line civilly in court. That is our response. In this case, a license survey was completed and evidence of that was shown to staff in form of pictures and things like that, which is what allowed staff to, I don't believe the property line is in question. It was surveyed by a licensed surveyor. I believe the location of the property line, unless a counter surveyor comes in and says, no, in fact, this was done improperly, or here's my take, then I believe a licensed surveyor, those markings are, that's what we use when we go and measure, for instance, a new house that's being put in. There's licensed surveyor markings. There are stakes for the corners of the house, and that's what we do. We measure from the licensed surveyor line to the stakes. That's
But
how
you don't do that on fence permits.
That's correct.
Okay,
You know,
that's what I thought.
here's the irony of the whole thing. We're holding up the issuance of the variance to be determined if the fence has to be moved. That's basically what we are.
No, we know the fence has to be moved.
Okay.
If it's
Do we, Leo? Do we?
it's on somebody else's
No.
property, John.
Hear me out, okay? We just had where this thing has been challenged in court because of the time.
Oh, but they haven't made that.
No, but,
They're nowhere near that.
but they could. He could challenge it under that.
Well, it's gotta be 20 or 21 years, and it's not,
No, it was 20 or 21 years. That doesn't mean another judge would rule in favor at 15 years or 19 years. That's an interesting thing when you go to court.
I really don't think the this is my opinion, but I really don't think the landowner would have had any issue at all in leaving the shed where it's at and moving that section of fence. I don't think he would have had any problem with that at all. He would have got his variance granted
Well, we
anyway.
never asked him.
So,
We never asked him.
because you guys were all hung up on if we can enforce him to move the fence.
We never,
Do you wanna ask me?
yeah.
I'm gonna move the fence.
Unfortunately, you guys have motioned and.
Can we motion to get this done? Give me a
At,
variance on the shed, I'm planning on moving the fence.
at this point, unless a motion is made to reopen the hearing, such a discussion is not proper.
As much as I would like to do that, and I think that's a prudent thing to do, I think a logical thing, since we're hung up on this as a board, is we get a legal answer. So if we ever have to deal with this again, we'll know which way to go. Again, I think a prudent thing, we should have asked. We didn't. We got hung up, as you said, on legality of the fence. Let's keep
John,
it.
we have had hearings in here on fences
This is the.
that were just measured with a tape measure, and they were said to have been off. And we have made the people move the fence. We just had one where we had to move the new fence back 1.5 feet from the sidewalk, because someone thought it looked too close. And when they measured it, that was, the new fence, we made a condition. Put the new fence back where it's supposed to be, back in the setback. See,
You know, let's get the legal
that's what we're gonna do. That's what we already voted on.
Find out.
21st.
So we have all this hearings in the past on fences and fences and fences and fences and fences. But now all of a sudden we have no authority on fences. I don't get it. I'll get it. So anyway, we'll talk about it after the meeting. It's mind-boggling to me. We issue the permit. We do go out now and
Okay.
supposedly look at let me finish. We go out and we look at the area, and the fence permit is granted, not based on a survey, probably never got the tape measure out. You just go out and say, okay, this is where they got it growing, okay, that looks good. And then, if an issue comes up with a neighbor who decides, oh, I think that's on my property line, then a survey's got to be gotten and all of that, and then the zoning department's gonna go and tell the person, oh, yeah, your fence is 2 feet over on their property, you need to move it. Not come in for a variance,
No, and then, yeah, they come up there and say you need to move it.
and that's what I was trying to avoid, by just doing it as a condition. But go ahead,
I just want to make sure that that is something that we can do.
that's fine.
And I think we spent enough time on this, we told these people, there's a disagreement on the board, we're doing it the right way and how to do it. I don't think we need to take any further action on this than what we've already
Well,
done.
we've already voted on it.
So,
Do we need to come back for this meeting, or,
you'll get the
I mean, will
notification.
we talk again or not? Or is it over?
So my understanding of a continued case, a tabled case that's brought up again, is you may request that all to happen again. You may request, people to come up and say their piece again, or you may say, hey, this is, what we've heard, and so those are the facts that we've heard, and now here is the new information we are trying to.
Basically, unless
Will you put another notice in the paper and all that?
Yes.
you have
Okay, so,
unless you guys have something new to present, all right? All we may end up doing is just saying, okay, what's the legal ramifications, what can we do, what can't do, they're gonna tell us, then we'll go ahead and, make a proposal for that and vote on it, without really opening up to anybody else. That's our option to do. Again, to follow the format though, we're gonna have to say, okay, anybody wants to come up and speak for it, come up. Anybody that doesn't want to come up, the primary.
so the answer to your question is no, you don't have to be here.
We're gonna basically wait and get the official interpretation that we're looking for read into the records. That's why she's gonna have to come in, or we're gonna have to have, so we get the interpretation that we can then make the decision on which way we wanna go. I may be speaking out of turn for the board. I don't think the issue of the variance on the shed is the stumbling block. It is the fence.
Yeah, pretty much, yeah.
So with that, is there no other case?
There are no other cases, however, you do have,
Yeah.
5 sets of minutes.
We're not gonna be discussing anything else, about this case, so if you wanna leave, you can, we're gonna be going through some.
Can we stay for the entertainment?
You can if you want.
Thank you.
I have to really, thank all of you, because, this is what it's about. A lot of times people think that we just understand, boom. Now, this is a good indication, there are some disagreements.
Right.
And
Thank you all.
Just a general thing. Would it be possible in the future, when people want to put up a fence, that it comes with a survey? That's a requirement by the township?
That would have to go through the town.
I mean, that would stop what you were talking about, where you're just eyeballing it, and then you run into problems.
I think it has to go through the law.
It's not a required thing, I did, probably have to go in and do all kinds of legal stuff to change it.
Yeah.
It's a good point.
It's not a bad idea, though.
Well, because
Even if
this
it's not required.
this whole thing pivoted on the line, and that, it's, yeah.
But
All right, thanks.
they're both in agreement on the line.
Okay.
I think they are.
That's the way I
See,
do
my,
it.
my problem is that there was testimony that they may not be.
There was what?
The problem is there was testimony that they may not be. Because when they brought up the adverse possession, that's testimony that they're not sure that that is the property line. So if we make a statement that says.
No, that he made a comment that they were wooden stakes. And then the other guy said, oh no, they were iron pins. And that's what the surveyor said of his machines and everything. So, sounds like it was an official survey to me.
You know, and it is a shame, we all know what's driving this.
Yeah,
But
so
we can't
I can't.
use that as a reason one way or the
Oh,
other.
I'm not, nobody's.
Well,
No, I know you're not legal, but it's sad, the people across the street from us, this is
Are
how
we still
surveys
recording?
go
Are we
crazy.
still being recorded?
We are still recording
Until the
and
meeting
actually,
adjourns.
yeah, until the meeting is adjourned. We should continue with the minutes.
Yeah.
Let's do
Okay.
it.
Let's go ahead.
That case has been
Do we have
tabled.
those pieces of paper?
I'm sorry,
Do we have the minutes pieces of paper?
you were emailed the minutes, is that correct?
Oh, yeah, you guys were emailed, these are really, go back to,
Oh, boy.
ironically.
Mr. Skaggs.
Yes, Mr. Staggs.
Yeah, I saw his,
Hey, you wanna look over these minutes?
Those were mailed out on 4/18.
Yeah, okay.
They were mailed out?
Yes,
Mailed. What do you mean?
No, no. What do you mean?
that was when I sent the meeting minutes.
I never received anything in the mail.
On April 18th?
I thought we got,
I thought you were sent a roundup of all of these minutes recently.
No.
not
I
on
know,
this.
I sent them, so
okay.
the first month after that meeting, you guys weren't ready for reviewing them because you wanted another month.
Right.
So that brought it into May. Well, then we didn't meet, I don't think, or we did, and we forgot to,
We did not meet in June or July.
we forgot
Oh.
to bring them up again in the last meeting we had. So now they're here.
Okay.
The other four there were some contingencies, or
Three.
they decided not to hear, and so they were small.
3 of them were fences.
Yeah.
And one was a pool.
I don't have any of those with me.
No, I didn't bring it.
I'm sorry, but when all that concrete, we'll talk about it off the record.
Yep.
Doggy daycare, and, I'm sorry, I
No,
don't have these, I
You
can't read them.
feel unprepared?
Yeah, I think we need to table
So,
the
yeah.
minutes
So there's a
until,
September 21st, we, in agreement, board, read these for that?
Sounds good.
do
Sounds
you
like
want
we
me to
get these
resend them
minutes.
all out to you again?
Yeah.
yeah, that would be the prudent thing.
That would be the prudent thing to
You
do.
talking about in the mail or email?
Email.
Email, okay.
We'll put that on the
You
agenda.
know what,
for
I
the
think
21st.
I do remember those emails now.
That being said,
Because it
Because the
was,
doggy daycare one was pretty lengthy.
Yeah, it was.
that's why they weren't ready, you guys weren't ready to approve them the month that we came back with them.
The
So we-
granting of variance from when you get the lawyer, does she have any weight on 1, 2, 3, 4, 5, 6, 7, 8 criteria?
the correct, like,
Does she
Should
put a
they-
weighting to any of those? Or are they all equally weighted?
you know, that's a good question for her. I would assume that all criteria are really binary, right? It's either they are met or they are not met, and the code states all 8 criteria shall be met for the board to grant a variance. So I don't think you can weight them because they must either be met or
Well,
not met.
We've strayed from that before.
Well,
Okay, that's a question.
yep,
And then you're gonna ask her questions about the fence. And what else?
So since we can't finish, should we finish the meeting?
Yeah,
first?
finish,
Yes.
let's finish the meeting.
that's,
Well, I'm trying to get there.
No,
You said you have to get that specific, what she's gonna do.
right, which,
It's part of this meeting.
Okay, okay.
I think if you, again, if we're talking about the information that the board is seeking in order to make a more informed opinion or
Right.
decision, you are looking for legal opinion from township legal counsel, about the limits of the authority of this board regarding the fence.
No, this specific case, granting a variance for the shed with a condition.
Right.
It's that simple.
That's, well.
What's your answer?
Okay.
That's fine.
That's
Sure.
one question. We still want that question about the fence.
So
Because that one we argued among.
That's-
whether we
that's
We
what
have
it
a
is.
can phrase it separately in that
Separate
sense. Sure.
question.
You could also, here's the thing, she'll be here, right, at the next one. So any specific questions that you have, should be able to answer them at that time. I
What-
believe there is no reason that questions couldn't be formulated in the meantime and sent to me,
Yeah,
and then
it's-
sent in advance to Dawn so that she has time to
And
prepare.
that's what I was gonna ask and recommend. What's the time frame that you would need the questions to be able to get it formatted for her to do the research? What's our time?
I would, request that any and all questions were to me no later than the last day of August.
Okay, so let's,
We do know the foundational questions, which we can start to prepare her for, but if you have any specifics, and then you can indicate whether you want those specifics, you want to ask those specifically in an open meeting or not, that would be fine too.
yeah, and I think that's a very good point there.
Yeah.
There may be some things that we don't really need to be addressed in open forum.
And that's what I'll discuss with you after as a board, so, but go ahead and finish that.
And so you said there's also the eight criteria or nine criteria, eight criteria for granting variances. You said there's that verbiage for us to approve or disapprove. Is it in this book?
Yeah, it's in the.
It's somewhere in this book?
Yeah, it's in the zoning resolution.
Yeah.
It's in the Board of Zoning Appeals article.
Yeah,
Okay.
page 229, I think.
What is it?
I think it's page 229,
Under
because I've been looking at the,
whichever, Eric? Oh, section 22?
there's pages at the bottom.
Oh, and they may or may not be the same, although I think you all got updated books. if I'm
We
not
did.
mistaken, right? Okay.
Thank you.
I think that's what you're talking about.
Yeah,
That's what I wanna
believe
know.
It should be right at the top of the criteria,
I
right
wanna-
before it
I want to
says
reread those.
all 8
Okay.
criteria shall be met or must be
I
met.
do, but I
Yeah,
didn't know about
it's
the
page
shall.
229 and page 2.
Yeah, no,
The shall is very
right,
contractual.
right.
And the legal aspect it is.
Yeah,
Without a
no,
doubt.
that's the scary part.
So, since we've determined that
But we don't know what
you'd
injury.
like to additionally table the agenda discussion, we would request a formal motion and all that as well, naming the time and place for the agenda consideration as well.
Last item had injurious, meaning to
That's
hurt.
boy, get ready.
Number
for-
4 has
get
to
ready
be,
for
it has to be
Number 4.
injurious to. So I have to understand what she thinks injurious is.
okay.
Because if it just means like, oh, I'm upset, then I can't breathe.
Well, and she might say it's just a question of fact that we can determine based on
Exactly.
credibility.
Exactly.
And I think that's what's going
But,
to be.
so we need to do a motion for what now?
To table the discussion of the minutes.
I thought we already,
I don't believe there was a motion and a second.
Not really.
so we have a motion again to table the motion on the approval of minutes.
No, make a motion
To table the,
to table the
The review
1,
and
2,
approval
3,
of the
4,
minutes.
5 sets of minutes. Right,
And
Yeah.
table that until September 21st.
right.
next meeting, right?
Next
Mm-hmm.
week.
Yes.
And it will be down back at the trustees meeting. It'll be done by
Can I second that?
Okay,
Sure.
do we need a roll call, or can we just,
Say aye.
all in favor, aye?
Aye.
Excellent. I have no more business for you, board.
We close.
Make a motion to adjourn.
Here,
A second.
for now.
All in favor?
You got it.
All in favor, aye.
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 Hold on.